The session will be on legal issues associated with data technology. So about Neema. Neema is a co-founder and head of legal at Sharia Kiganjani. Neema is an experienced managing partner with a demonstrated history of working in the law practice industry and advising across a full spectrum of legal transactions, ranging from straightforward commercial practice to more complex transactions involving multiple companies and clients. She is skilled in corporate and intellectual property practice with vast experience in the two fields. She provides intellectual property services in both Tanzania, mainland, Zanzibar, together with Aripo. Her extensive knowledge of local and international regulations well positions her to help clients around the world deal effectively and creatively with regulatory and compliance issues. So Neema is one of the co-founders and head of legal for Sharia Kiganjani, a digital platform that provides easily accessible and affordable legal services through the phones over 40,000 Tanzanians who cannot access justice due to financial and geographical constraints. So I'll hand it over to you, Mahadia, and Neema, welcome. The floor is yours.
Thank you so much, Philomena. Neema, how are you today?
I'm fine, Mahadia. How are you? Happy International Women's Day.
Thank you so much. I know you have heard a lot of buzzwords coming from the legal background, but you are the unique person here, especially from the speaker's side, in a sense that you are bringing in the new perspective. As we have been talking about these, developing products on the data science products and AI products, and we have been talking about the misdiagnosis that could happen. So I wanted to ask Neema, is there any legal implication on the breach to data privacy?
Thank you, Mahadia.
Because we are talking here about data sharing, but then when we talk about health data, it's a bit sensitive. So I wanted to understand if there are any legal implication towards that.
Thank you, Mahadia. So before I get to the legal implications, I think as the previous speakers have, I'll repeat to acknowledge that over the past few years, there have been a lot of technical advancement and a lot of growth, especially in the health sector. The use of biomedical data has created a lot of opportunities, which we've seen, and which have already been presented, of course, to advance health. So I think we should acknowledge that again. But we already know that where there is a lot of advancement, challenges tend to arise as well. So with the increase in technological advancement, there are also challenges that have come about. And when we talk about breach of privacy, challenges to protect the privacy and security of patients and other research data is one of the most important or the greatest challenge that has arisen over the few years. So when you speak of general implications, before I get to the standing of Tanzania, generally we have there's a common law principle. I'm talking about common law because Tanzania accedes to common laws. So there's a common law principle of medical confidentiality and duty of care. This principle binds all health and medical practitioners, and it's not just binding the physical nurses and doctors that we find in health institutions. This principle also binds health applications that are also providing health advice or diagnosis online, as Dr. Salome mentioned during her presentation. So number one, medical practitioners are bound by this common law principle of medical confidentiality and a duty of care, which protects patient information from information like diagnosis, treatment information, medical test results, and prescription information as well. Now, when we come to the Tanzanian setting, although we don't have one single codified data protection law when we talk about breach of privacy and data, but we have, there are different laws in Tanzania that provide for data protection. So we don't have one codified data protection law like other countries, but data protection and privacy is provided for under different laws. And just to highlight, one of the most important laws that provide for this is the mother law, the Constitution of Tanzania, and Article 16. It provides for the right to privacy. But we also have the Cyber Crimes Act. It also provides, it prohibits data espionage, which also extends to unauthorized access to medical data and unauthorized mishandling of patient information. Now, under the Cyber Crimes Act, this is a criminal offense, and the sanction is a fine of not less than 20 million and above. So to simplify my response to your question, there are two legal implications. You can have a criminal legal implication under the Cyber Crimes Act in Tanzania, but they could also be civil sanctions, as in a patient or a subject to the breach, a subject whose medical information has been mismanaged or whose privacy has been breached, can also sue for compensation in a civil suit.
Thank you. Thank you, Neema. Clearly, you got me scared. I never knew I'll have to pay that much amount for just sharing the data illegally or the breach to private. So this conversation is important because as the data scientists, we keep requesting for the data from the government and elsewhere. But then understanding the legal implication is important in such a way that sometimes as students, as just team members, you just share a data in your flash out of a goodwill. But then if that data gets to the hands of a wrong person, that means you could be in trouble. That means we could be paying about 100,000 USD for just that. So, and that is the minimum amount. And it's a criminal law. So thank you for highlighting that because it's important to understand. I wanted to ask generally, is there any legal implication of AI in terms of recent, for instance, Dr. Salome was presenting on these misdiagnoses, like you can develop a product and can be giving wrong prescriptions. You can have a car model which causes safety concerns. Is there any legal implication when it comes to AI products and services?
Thank you, Mahadia. So yes, there are legal implications when it comes to the use of AI. And one of the two things that I would highlight on the use of AI, or what AI would cause as a legal implication, would be one, of course, the breach of the data that's been used by the system that has been developed. But also there's a case of misdiagnosis by, again, those applications that are using AI, as Dr. Salome had highlighted, to misdiagnose and provide wrong information or wrong prescription to a user. But then again, there's also issues of cybersecurity vulnerability, because this information is also stored online. And with the increase of the use of the internet and technology and data, there's also an increase of the risk of this data being breached, and of course, the cybersecurity vulnerability. Now, in Tanzania, again, I think it's important to note, just to go a step back, that there are no really strong, stringent criminal sanctions for doctors or medical practitioners, in a sense. So when it comes to issues of misdiagnosis through AI or mishandling of patients' data, there are ethical policies that govern doctors, or that doctors are bound by in Tanzania, of course, including their doctor's oath. But when it comes to criminal sanctions, we are lacking on that. So again, as I explained on data breach, a patient or a subject of the legal implications I mentioned that AI could cause is able to go and has room to go sue for compensation in a civil suit. And since doctors are also, I mentioned that they're bound by their ethical policies, health practitioners or doctors they're answerable to their respective interdisciplinary bodies that have been developed. So let's say with Tanzania, the Medical Council, which have been put in place by these respective policies, doctors could answer or be answerable to them. But as a patient or a subject of the legal implications, you can sue for compensation. So again, as in data breach, as a remedy, you can sue for, you can seek for criminal sanctions or seek for civil sanctions, and civil sanctions are the most common with patients, because again, until a doctor, until a medical practitioner is held criminally liable, it's for the government to sue and not for the patient themselves. So again, the liabilities are the same as when it comes to data breach.
Thank you. Thank you so much. I think these conversations are important just to raise awareness, not only for the data scientists, but also for the policymakers. If there is a caveat, then, and we are going towards the fourth industrial revolution, data revolution, etc. So I think having these policy and legal frameworks in place, it's quite important. But for the data scientists, understanding these legal implications is also important so that you are not caught into trouble. So for the interest of time, I know the next speaker is Tricia from Johns Hopkins. So the timing difference is a bit challenging. So we'll only take one question from the floor and one question from online, if any. I'll start with you, Philomena. Do you have any question online?
We have one question from Patricia Boshi. She's asking, as you know, data is important for development and innovation. Medical data specifically is important for scientific reasons. For example, a researcher may need patient data to be able to come up with vaccines and cure. What is the legal position in Tanzania in terms of sharing patient data for scientific purposes?
Should I proceed to respond?
Ed?
Yes, so as I mentioned before, we do not have one single codified law that provides for what should happen or what things should be taken into consideration when you're sharing data, which also includes patient data. But I did mention these principles that bind legal practitioners, like medical confidentiality and duty of care. So these are things that should be taken into consideration when medical practitioners want to share patient data for these scientific purposes. Things like seeking consent of the patient are very important to ensure that you're not you don't eventually fall into the implications of mishandling that patient's data, or for a patient to come forward and say that I did not authorize for you to share this data with me. So things like consent should be taken into consideration when you're sharing this data, and general general duty of care when you're handling a patient's data should be emphasized. But there is no specific codified legal provisions that tells you what should be done when you're sharing patient data.
So yeah, so we are told to always seek for consent, because you never know what will happen next. I'll take one question from the floor. We have one question, and then we'll go for the next item in the agenda.
Thank you. Thank you so much, Neema, for the insights. My name is Nurat Karamagi, data science scholar from dLab. I'm having this one question. Most data scientists do not know how to protect what they own. So can one patent a data science product? If yes, how is the process?
Thank you for the question, Nurat. And I think that was one of the things that I wanted to highlight last, on the importance of data scientists protecting their intellectual property rights. With the advancement of technology and with the continued use of tech solutions to cater for health issues, there is a need or an importance for data scientists to protect their work and to protect their inventions. So yes, you can patent your inventions, but the process is a little bit, I won't say complicated, but there's so many there are so many criterions that you would have to adhere to in order for you to be able to patent, because with patent, it has to be an invention, something that is new, that has not been invented anywhere else, and you are the first person to invent it or bring it to life in
So I think she has partly responded on the challenges being, it's difficult. I think
can be done.
Gone.
Mahadia, you were saying?
Gone.
Yes, so I was confirming that the process is doable. You can patent your invention, and I will leave my email address in the chats just in case there is a data scientist or anyone in the conversation who would want to know more about the processes of patenting in Tanzania. It's a huge topic, and I don't want to use much of your time, but it's something that's doable, and I'm open to explaining this further. If someone wants this information, you can just reach out.
Thank you so much, Neema, and thank you so much for being here with us today.